Now it's recording. Good afternoon. It is me again, Chris Bacon, the brain injured guy. Sunday, October the 6th. It's 12:26 p.m. here in Waterloo. Anyway, don't know if you saw the last one that I posted. It was starting to read was actually in the bylaw. There was a note I added to it. Again, before I start, I'll dedicate this to the Grenfell Tower fire victims from London, England. That's that big tower that went up. It was under construction, and all the fire retardant materials weren't fire retardant. You know, many lives lost. They're still sorting that stuff out. That was back in 2017, as a matter of fact. Anyway, much the same thing as what was happening here. They're overlooking and giving shortcuts, it appears. And when are we going to have our Grenfell fires, that Grenfell Tower fire? Is that when it's going to take for these people to get that this is against public safety, that this is wrong on so many levels? Plus, they are in contravention of their own acts. Right now, Shayne Turner and the Municipal Enforcement Division is in violation of the Municipal Act and of their very own bylaw, because it says no person, which includes any person from a corporation, which includes the corporation of the City of Waterloo. So this is a we feel it's a cooperative thing. You're about to find out, because this is what it's really about. What we just found out ties it all together and changes the perspective of exactly how and why things happen the way they did, at least from our experience. And it's a good thing we documented this, because otherwise we'd have no proof. As far as the what happened next door, 98B, with the fire inspection, that didn't happen. Again, we challenged the fire department and the City of Waterloo to produce any fire inspection, physical fire inspection, that happened at either of these units since 2012, because it's our discovery that it's never happened. That's why that property at 98B was allowed to get a free pass again, exactly for the reasons that we're discussing here. Also, this property, 100A, failed the fire inspection as well. Those documents are posted on one of the other pages that I put up. I'm not sure which one right now, but anyway, it would be interesting. We documented the whole crime, because this is definitely obstruction of justice. In the very least, it's interference with our tenant rights and our tenancy directly. It looks like they participated in these acts. So anyway, let's get back to it. What this is about is this order right here. Sorry about this. This is the order that is still outstanding. It is written under Section 15.2 of the Building Code Act, which is the part that just gives them permission to do this. Says that they have the ability to do this. Okay? This order is only based on property standards, which is why it's under 2011-122. It has nothing to do with the rental. Actually, it's called the Residential Rental License Bylaw, because that bylaw is just a sec, it's 2011047, and that is the one that he's required to have the license. That is the one that says he is unable to collect rent and all that other stuff. He was never ever fined or registered any kind of matter with regard to 2011047, with the exception of they accepted his applications. And again, he falsified and gave knowingly false, or even, we know it's knowingly false, but even through this whole thing, you be the judge. He definitely did not file those applications properly. Those applications, and once you see what happened here, I think you're going to agree even more. But the biggest thing is what exactly is the region of Waterloo and the city up to? So here it is, the order that was written June 13th. Okay, so where does it say that? Well, here at the bottom, dated this 13th day of June 2019. It states that I hereby order that property known municipally as 100A Marshall Street, Waterloo, Ontario, being in the City of Waterloo and the Regional Municipality of Waterloo, and more particularly described in Schedule A, annexed hereto, to be brought into conformity within the said bylaw, by July 15th, 2019. Now what they say by Schedule A is this here, which this is who is notified. That's the lot. And also who is notified is in, sorry, it says Schedule C, I believe. Take further notice that the person served with a copy of the order in accordance with Section 15.2, subsection 3 of the Building Code Act for the province of Ontario as amended are set out in Schedule C, annexed here 2, which is the final page. And that shows who it was. Oops, sorry, bear with me. Oh, sorry, not that. This is the other part of my presentation. There you go. So this is number 3. Schedule C at the top, partially cut off, but it shows that it's 2011897 Ontario Inc., which is a corporation. 455 Old Oak Drive, Waterloo, Ontario. If you require any further information and or clarification, please contact Allison Henshaw, Licensing and Standards Officer at 519-747-6263. So if you think that this should be honored and it still hasn't, then by all means, please feel free to give Allison a call at that number and say, fulfill the order. You're wasting our tax dollars, and what are you getting paid for? Anyway, so again, this is the order that's outstanding. Let me just go over it. So July 15th, that was exactly, as of today, 83 days ago. It was written a little more than so maybe 30 days before that. So it was June 13th, it was written. So they were given a little more than a month, a little more than 30 days to do this. So you add 30 days to the end of this, you're talking 113 days since it was written. 82 days since it was supposed to be fulfilled, where they have the ability to actually come in here and do the repairs and send him the bill. They could do whatever they want, but it's all controlled by Shayne Turner. And that is very important. Shayne Turner is the one who gave every single residential rental license before this incident. He is also the one who signed the residential rental licenses on every one of these properties. So again, this is not a trifling thing. This is the actual order. These are the infractions. There are 22 infractions which are designated for 100A, but they made a mistake because, again, the chain link fence is not ours. The chain link fence actually belongs to 98 Marshall Street. I was just using it as a comparison because he promised us a fenced-in backyard. And it was supposed to and finish the fenced-in backyard that was started before he bought the property. Again, that's part of the verbal part of the agreement, but he is required to take all verbal parts of the agreement to constitute into the agreement and then provide us a copy, not the other way around. And the verbal part of our agreement was captured on recording, digital recording, word for word, verbatim. Soon to be used against him, because the problem with the landlord and their arrogance is that through the Landlord Tenant Board, because they scared us away again using our disability against us by not making us safe, they were able to tell whatever story they wanted to, and quite the story they came up with. But the problem that he doesn't realize is, both he and his lawyer don't realize, is that that was totally under oath. That every lie that they told is now registered under oath, and that becomes perjury. We are requiring the landlord tenant, again, we tried to contact these people. They are not cooperating with us in any way, shape, or form. None whatsoever. They are doing their job, which is to shut it out. We are asking verbally under Accessibility Ontarians with Disabilities Act that the Landlord Tenant Board immediately cease any and all actions with regard to eviction. We automatically ask the Landlord Tenant Board to take all recordings of that hearing on August 28th and to preserve them in their entirety and to have them transcribed and us to have a copy of it, especially the part after we left. We need this in order to properly adjudicate this case and show the whole matter of this case. Okay. above all else, we need the regional municipality of Waterloo needs to enforce this order. It also says here, sorry, I'm getting a little loud. Sorry, it also says here, take further notice that under section 15.2 or parentheses 4 of the Building Code Act for the Province of Ontario as amended, this order may be registered in the appropriate land registry office for Waterloo. We attempted to do that a few weeks ago. We brought it in to have it registered, and they told us that we weren't able to register it at all. We would have to hire a lawyer, and only a lawyer with real estate license was able to do this for us. This should be changed. If that is in fact true, well, first of all, we ask under Accessibility Ontario's with Disabilities Act that be waived. We ask that because this order is so outstanding that the regional municipality of Waterloo and the city pay for it to be registered, because we believe the reason why they're preventing us from registering is because of the land deal that they're doing behind the scenes. Again, I don't know, and again, how is that highly obstructive? We don't have time to do any of this stuff because it's just more roadblocks, and we got to sit here and decide, where's our resources better spent. We have to pack in case we're not able to cease this, in case we're not able to get the proper representation. We haven't even had proper representation of the law or application of the law. And this is taxpayers' money that's being used for this purpose. So Alison Hensall, as a person, is obstructing. Shayne Turner, as the director, is obstructing because he's preventing other people from coming out. And I'm going to elaborate on that in a minute. Because we did, in fact, get in touch with Mitch Brown, who is the building inspector for the region of Waterloo and province and whoever else. Okay, we'll be doing that. So it's really hard to do this with one hand. Anyway, what I'm doing with this here is I'm showing you that this again shows that as of, and this is with relation to what's going on next door with the fire thing too. This is a copy of the letter. Again, it's in some of the links. You'll be able to see it. It's Marshall Street Tenant Association, officially formed, care of 100A Marshall Street, Waterloo, Ontario. City of Waterloo Municipal Enforcement, Mayor Jaworski, Shayne Turner, Shamir Mehta, Alison Hensall, the Region of Waterloo, Waterloo Regional Police Services, Public Health, Chief Medical Officer of Health, Province of Ontario, Attorney General of Ontario, Ministry of Municipal Affairs and Housing. I don't know how much more clear you can be than that for who's addressed to you. Friday, August 16th, I think it says 16th, yeah, 16th, 2019. Please be advised that we, the undersigned, have agreed to form a tenant association as we are the legal tenants of the said rental properties and have similar shared legal rights and interests with regard to the execution of the management and rental of these properties described as follows: 98B Marshall Street, Waterloo, Ontario, Norman 2 Jack 2 Terrence 4, and 100A Marshall Street, Waterloo, Ontario, Norman 2 Jack 2 Terrence 4. In the region of Waterloo, in the province of Ontario, Canada, and as a tenants association, namely the Marshall Street Tenant Association, we also acknowledge and appoint Christopher Bacon as our spokesperson and main representative and has the authority to speak on all matters on behalf of the Marshall Street Tenant Association. Dated on this, the 16th day of August 2019, the City of Waterloo and the Regional Municipality of Waterloo in the Province of Ontario, Canada. Signed by Carrie Mills, tenant 98B Marshall Street, Waterloo. Denise Duval, tenant 100A Marshall Street, Waterloo. Christopher Bacon, tenant 100A Marshall Street, Waterloo. Also, by signing above, I, Carrie Mills, do hereby request a full housing inspection including the Ontario Building Code of the rental property known as 98B Marshall Street, Waterloo, Ontario, Norman 2 Jack 2 Terrence 4. It is my understanding that the landlord already gave his full permission to fully inspect the premises as part of his rental license application, which is also currently under review. I request this to affirm the true legal standing of the property in order to properly administer my rights as tenant in Ontario. And then we did the same thing, same declaration, but I'm going to read it because we should. Also, by signing above, we, Denise Duval and Chris Bacon, do hereby request a full housing inspection, including the Ontario Building Code of the rental property known as 100A Marshall Street, Waterloo, Ontario, Norman 2 Jack 2 Terrence 4. It is my understanding that the landlord already gave his full permission to fully inspect the premises as part of the rental license application, or his rental license application, which is also currently under review. I request this to affirm the true legal standing of this property in order to properly administer my rights as a tenant in Ontario. This was sent to them directly. So that is proof that we formed a tenant association, which the Landlord Tenant Board is required to acknowledge, that all of them are required to acknowledge and none of them have, because of what's going on with this rental license fiasco. It's actually a scam. We've proven it, and we're about to prove it to you. But this is also showing that August 16th is when we asked them to do a full inspection of 98B as well, because of our suspicions. They, well, you'll see what their answer was. So you'll see what their answer is. But before we go there, I don't know how much time we got so far. Oh, just 15 minutes. Okay, before we go there, there's one other thing I've got to do here, and this is the important part. As I said, we actually got a hold of the building inspector for Waterloo. And what I'm about to play for you, I'm going to play it on, because it was captured on my iPhone. Now again, as a person with a disability, I've got a brain injury, and I know it doesn't seem like it, but I've got memory problems and stuff. You wouldn't believe how long it took for me to try and organize things to be able to try and do this. So that's why, and it's still disjointed. Anyway, so as a person with a disability, I have a brain injury with memory problems. Every business transaction, especially dealing with government and medical and stuff like that, is recorded, because that's for me to participate in my own life. The only way that I would be able to remember it, except for the traumatic parts, I mean, those are real easy to remember because they keep coming and they keep doing it. But I mean, sorry, this is just so hard. But that's the whole point, right? That's what I mean about using your disability against you. As part of my disability, like I said, I'm able to do that because it's for me to participate in my own life, and that's the part that they didn't count on. And I didn't realize the importance of this until many years of going through this, and that's why they're afraid of me now, because this is the evidence. This is why they cover up for the court at Waterloo Regional Courthouse. Why you can hire a lawyer, and anyway, there's the whole story here. It's all documented. You just need to look at it. Nobody wants to look at it. What is your sensibility? Who knows? But anyway, let's get back to the point. The point is, I have a phone call where it was September 3rd, 2019. They keep saying that I'm the problem because I'm antagonistic, and again, yeah, I get upset and stuff like that, and they've certainly used me as a meat puppet by pushing my buttons and always antagonizing with the police. Again, we ask for liaise, we ask for somebody to be a buffer, and they always come over with as many uniforms as they can, going, "Hi, it's Chris here." And when there was 6 of them that almost beat me to death on the doorstep of the courthouse, so and they've been getting away with this for so long, and I'm about to post a lot of other contact videos showing the Waterloo Regional Police's tactical response to disability and their training to be inclusive and stuff like that. Well, they use words like that. You can watch the videos for yourself and you will see. I'm starting to post videos about all these contacts, because this is not an isolated incident. This is a pattern of behavior. This is deliberate. That's what I think from our experience, and that's what we're going to show, because you know what? I don't care anymore. I'm posting the videos. You can be your own judge. Anyway, as I said, this is a phone call with Mitch Brown. He is the building inspector for the Regional Municipality of Waterloo, hired by the city through Municipal Enforcement, which is under Shayne Turner. Again, September 3rd, 2019. It was 19 minutes and 58 seconds that we had this conversation. A lot of it is me asking him questions about the situation. That it is a little bit long, but it is well worthwhile listening to, because this is how it should have happened. This is how easy it should have been. When we made the call, they should have sent a building code inspector and municipal inspector at the same time. They could have sent an officer if they wanted to. They don't need that, though. They only usually do that when the homeowner is being belligerent, when they're refusing to let them in. So the only reason why they kept doing that is to paint us that way. Again, they're trying to control the narrative, and you'll find out why in a minute. Just bear with us and go through this. Anyway, so there was actually 2 calls, because I got a call from Mitch on September 3rd which lasted 19 minutes and 58 seconds. And you'll see how, when applied properly, there's a way for us to get through what we need to for my disability. But again, Waterloo Region and all them are supposed to have a person in place that is supposed to be a buffer. That if you have a problem communicating, they are specially trained to deal with persons with disabilities to help facilitate what you want. Not to get you into a position where you're pissed off and they just get you angry and then they go, well, you're being belligerent to me, so now I don't have to deal with any of it and you're gone now. And your issue doesn't get held. It's the same as Trudeau trying to, it's the same as Jody Wilson-Raybould trying to get to Trudeau. And she was the Attorney General and Justice Minister of Canada. When you have a legitimate question, they just refuse to answer. Oh my God, it sounds like Trump, doesn't it? Anyway, it must be contagious. So, here we go. I don't want to do this much more. I'm going to post the actual copy of the call, a link to the actual call. It's called C of W, which means City of Waterloo Building Code Inspector Mitch. And you need to hear this. Okay? Anyway. I'm just going to call the City of Waterloo just for a general question. 519-886-2310 is the number that we're doing for that. So I'm going to call them and just ask them a question about whether owner-occupied or non-owner-occupied rental needs a deck. See, at first I didn't even realize that this is the guy I was supposed to be talking to.
Welcome to the City of Waterloo Service Center. If you know the extension of the person you're trying to reach, please dial it now or press pound for the voice-activated staff directory. For seasonal information, please press star. Please be advised your call may be monitored for improved customer service. For water services, including billing, stormwater credit program, and water quality issues, press 1. For purchasing, press 2. For forestry, including tree-related information, press 3. To reach customer service staff for all other inquiries, press 4. To repeat these options, wait while I transfer your call.
And I believe I just looked up the number on the website. So I called the number on the website.
Waterloo Service Center, good afternoon.
Yeah, hi. I was wondering if I could just ask a general question and see if I can get an answer.
Sure,
Regarding
go ahead.
permits.
Parking permit
No,
or building permit?
Building permit.
Building permits? I'll transfer you through to building services. One moment, please.
Thank you very much.
You're welcome.
So they're called building services, not bylaw. Bylaw enforcement is strictly for, anyway, confusing.
Waterloo Building Standards, Mitch speaking.
Hi Mitch, how are you doing?
Good, how are you doing?
Not too bad. I just got a question. If you're a rental property and it's not owner occupied, you need a permit to build a deck if it's over 24 inches?
Sorry, so you're the tenant, or?
Does that matter? I'm asking a general
No,
question. I'm saying if it's not an owner-occupied rental, so the owner does not live there, do they need to have a building do we need a building permit in order to build a deck if it's over 24 inches in Waterloo? Yes or no?
Yep, yes, you do.
You do. So if somebody built a deck without a permit, what happens?
We'd go out there and tell them to apply for a building permit.
So they would have to pay, yeah, but what I'm saying is, what if it's already been built? Then it's been there for a few years.
We'll still go out there and tell them to come and apply for a permit.
So they would have to pay for it, right? Even if it's already built?
Yep.
Okay. What about if there's repairs needed in the basement wall, like to a foundational wall? Is that considered changing the inside structure, which they would have, and especially when you're talking about a crack in the foundation, they would need a permit in order to fix that, right?
Yeah, anything structural that you're altering, changing, repairing, you're gonna ask for a permit for that.
What about a guardrail around that's metal that's affixed to the concrete. Would that
Yeah.
require a permit? It would.
Well, yeah, if you're putting up a new guard railing around a port.
No, not a new guardrail. They're required to fix it.
They have to fix it?
Yeah, it's been under order.
Okay, yeah, I don't know. What's the address of it? I'm going to have to look into this file.
100A Marshall Street and 98B Marshall Street. 98A Marshall Street and 100B Marshall Street because, well, go ahead and get the file. Let's see what you see. It's being handled by Allison Hensall, supposedly. It's now 51 days overdue to be repaired by the order. 81 days since he was given notice, 83 days since it was written.
Is that from bylaw or from the building department?
Bylaw. Why is there two different, like, are you the guys who do the building code inspections?
I am, yes, but I think Allison is in bylaw.
Well, I'm sorry, then we have been asking for you to come and do an inspection at this building through Shayne Turner since May. So you're the guy who does that, Mitch? We are requesting that you come and do a full building code inspection of this property.
Okay. Shayne Turner.
It was already given in writing to all these people, and right now Shayne Turner is in violation of his own bylaw because Allison wrote this order on the 13th of June. It was delivered starting 15th of June, which is why they were given 30 days until the 15th of July to comply with the order, as ordered by law enforcement.
Yep.
Okay? And there's building code infractions on there as well, which were noted. But we had asked for a building, and by the way, this is an application for a rental license where the landlord gave his full permission for any inspection on that application. He swore that it was already to code. It already met minimum standards. He made a legal declaration in that application for each of these properties. After being caught for not having the proper rental license and collecting rent and causing rent to be collected for 2 years since 2017. Bylaw did not send out the appropriate letters because they only sent one to one of the properties. They never sent out to all 4 properties like they're required to. They did not complete records in the municipal enforcement record with regard to complete records on each property individually as well. And Shayne Turner is responsible for this because 4 days after that order was written, Shayne Turner, against his own bylaw, where it clearly states that he is not allowed to give a rental license where there is any infraction of bylaw or building code, on June 19th, granted a rental license for this property, which has not been hanging to this day, which is against bylaw. So either way, Mitch, we are requesting verbally. Do you need me to send it to you in writing?
No, I just want to know.
So I'm asking you to come here and inspect one. Now, we ask that you review all 4 of those licenses applications.
Yeah,
and that you come and inspect all 4 properties for building code, because next door they have a deck that has black mold all over it, and it's a danger to everybody here, especially the grandkids. And Health Board has been ignoring it.
Okay.
And other people have been ignoring it, so we're not doing that anymore, Mitch. You need to come and inspect. Can you do that?
Rental licenses? I can't comment on any of them.
I'm not asking you to comment on it. All we are asking for is you guys are supposed to be impartial. We're supposed to go, like, first of all, this minimum standard states he's required to have it before he can even rent it. Even all the laws, including this rental license bylaw, follows that, especially with the building code. And minimum standard is not something you work toward. It's something you have to have a minimum of.
Absolutely.
Okay?
I totally agree with you.
Sorry, I'm really frustrated, but I just want to let you know, from my understanding, we've gone through this before. Building inspectors to show up and do an he's just got his checklist. You do an impartial, you just review the property for legal standing. Anything that's not to code, you do the same thing. You say, this is not to code, you must bring it into code before such and such a time and make sure it's brought to code, because no matter what happens, at the end of this process, when you guys go, we're done, it should be at least minimum standard.
Yeah.
Right?
Absolutely.
So, and again, impartial. So not this thing about, because we had bylaw coming here saying they didn't have permission to do it, even though we're the ones inviting them in about our concerns. They only looked at the things that we had concerns about. They did not, they said, we've got them on YouTube. You can go on YouTube because we videotaped it, where Allison Hensall is telling us, oh, I can't do this, I can't do that. And when we invited her in here, she's reading the warning every time, even though we're not being adversarial. But it demonstrates, and this is what was pointed out landlord tenant the other day, is that she has the right to enter, any inspector has the right to enter any building at any time. Usually what they do is they come to the door. If you're not home, they leave a contact. You get in touch with them.
Yep.
But the point is this: they say, I'm Mitch. I'm with the city or whoever. Here's my title. Here's my credentials. I would like to inspect this property. Is that fine? And the person could go, yeah, I'd like to do it, but not right now because I'm in the middle of something. You come back, make an appointment like next day or something. That's acceptable, right? As long as they acquiesce, right? If you refuse, then that's when you say, I'm sorry, but if you do refuse me, then what happens is I will leave here, I will come back with an officer, and I will ask you again. And if you refuse, then I will enter without your permission with the officer present, because I have the right to do that.
Exactly.
Okay? Go to YouTube and see what she's saying. Shayne Turner has been he's been handing them the property plans from the last owner, and they're just stamping it, re-signing it, because even with the property plan that they put in for the rental license here, there's no mention of the deck.
Okay.
The deck is already under order, and that deck was supposed to have permits. He did. Anyway, that's all up to you guys. I don't care. All I'm saying is I'm only explaining this to you because we feel we have been treated unfairly and they've been punitive against us. We don't care about anything else, and the system is doing what it needs to take care of that. The only thing that we ask from you, and this is the Marshall Street Tenant Association now, the only thing we are asking from you is to please do your job. Inspect based on the code, identify, have it, and again, it has nothing to do with who's at fault in this, because the law is clear. Regardless, it's the landlord, it's the owner's responsibility, okay? And the whole point is to make sure that the next time this is rented out, or if we continue renting it, it is what they claim it is. And we are looking into misrepresentation fraud with criminal, because he has done multiple documents, which we have confirmed through MIFIPA release. Okay, that's why I know all this information. And like I said, I'm apprising you of the level this has gone to. The fact that they have gone to great lengths to keep you from doing your job, and I finally find you now, is very interesting. But that doesn't matter. The system and whatever will take care of itself. What we are asking you to do is please do your job. Please make sure, no matter how this turns out, that it is corrected. Okay? That's the only thing that matters to everybody, and especially, not just the tenants, but especially all those legally operating landlords and property management companies and others that do follow the law, that do pay their fees, that do get the right thing. And again, they need education and leadership in this. Okay, that's the bottom line on everything. And as far as, this is no big get even. It's not about getting back at anybody. It's about getting what you're paying for and being safe in our home, because we were lied to for 2 years. There was a rental license hanging in this property when we came here. We came from another property in Kitchener that the city of Kitchener, after a year or more living there, saying it was legal, we found it was unlawful. When we came here, we said, we just came from an unlawful place. This isn't unlawful, right? And he goes, no, it was right on the application. This is the second real estate agent, because the last one was a certified real estate agent, just like this one is, both with development deals with the region, both getting a free pass. And that's not what I say. Go read the file. And if you like, I'll send you a copy of what I got. And you know what? They came to we had a hearing on Wednesday. They showed up, they were granted the license on June 19th. Okay? We only found out about it the other day on the 28th of August at the hearing, because they used it as a ta-da moment. And even judge advocate got it. Because your own bylaw says it's supposed to be posted.
Right.
So from June 19th, it should have been posted here. So for 11 weeks, it wasn't even posted. So again, he is in direct violation of the bylaw in spite of everything else. And the reason why he did not honor that order is because he didn't have to. He's got his license. Allison Hensall and the whole city did not do anything to follow up on it at all, except for when 98B, it was discovered, like the order, I don't know if you have it in front of you, but the fence that they included in the order, when I was giving my description, I was using it as a reference for why our two sides of our fence on 100A should be 6 feet. There's 6 feet on one side, 6 feet on the back. As a matter of fact, the back was made to be corrected. Because it used to be the same as the 4-foot or 3-foot fence, whatever the hell it was, right? And you can see where they put extensions on it in order to make it 6 feet along the back, which is why 100A has to be 6 feet on the back.
It's a good thing
But
you got
there's this
camera
one little fence
stabilization.
that runs between 98B and 100A that's incorrect. Obviously, they were both owned by two separate owners at the time, so they're talking about division property fence. They should have been corrected. Whatever happened, it doesn't matter. The point is, his project was stalled, and our fence is on our property. It is not on 98B. This fence is clearly 98B's fence. They included it in the order for 100A, which says that it's not to code either. So they judged 98B not being to code either, not being to bylaw, not being what he attested to in his legal declaration for 98B and also 100A. So you need to be, like, again, the only thing is the mayor, Steve Ross, Mr. Anderson, the chief administration officer, everybody has been apprised of what's going on. Okay, so we need you to do your job, please. When would you like to set up a time to do that? To come at least look at this, because the other thing too is you need to see that this license is not hanging here. We already reported to municipal affairs as well.
Yeah,
Enforcement.
I'm gonna try and get somebody out there tomorrow, so that's the plan.
That would be good. I would appreciate that. And Mitch, the other thing too is that I have a brain injury. I have PTSD. They have made a point of trying to provoke it by always bringing police out here. There is no danger for anybody, and you can see that from the last 3 interactions. I actually had to extricate myself because they were using it as a means of intimidation and provocation.
Yeah.
And we asked for community liaison. So if you don't feel safe, please bring a community liaison with you. There's somebody who works with the police that we worked with once. So any kind of buffer. But I'm telling you right now, there is no threat here from us. Just come here and inspect. You don't have to do all that other stuff. I'm asking you to, on behalf of Accessibility Ontarians with Disabilities Act, we don't need a provocation. There's nothing wrong here. Just, we will stay out of your way. Whoever's coming here, you do your job. And again, we need to stay out of your way so you can see what you're doing. Right?
Yep,
and that's the whole thing. So I'm trying to, and there's my caregiver is here, Denise. She's been here every time too. Whatever you need, we will facilitate. We do have a dog, so we will set him aside somewhere. Or better yet, you know what? I may just take him to the dog park again. Okay, and that way it's just you guys and Denise, and then that the same as last time. Then we remove the threat. Then that way, actually, that'd probably be the better way, because that way you don't have to deal with the dog too. So why don't we do it that way? And you do what you need to do, and that way there's no conflict, and you don't need any police officers and that and stuff like that, unless it's protocol, I guess, right?
No.
I'm not going to tell you what to do, but I'm just saying there's no need for the extra cost if you don't need to do it. Okay, so I give you my word right now, and my name is Chris Bacon. Okay, like I said, I got the PTSD, so I will remove myself. Do you have an idea what time you'd be coming, or even if you could text me like an hour before you show up?
Yeah, if I just get your phone number or email even, that's fine.
My email is CRI, S is in Stephen. Yeah, it's just crispy bacon, but it's instead of Y, it's
PY.
No, it's CRISPI bacon.
Okay.
crispybacon@hotmail.com. Phone number 519.
Yep.
603.
Yep.
4104.
410.
And it's myself or Denise Duval. Denise Duval will probably be the one who will be meeting you here today, or tomorrow.
Okay.
Tomorrow, okay?
Yeah.
And actually, Carrie has 98B. You can make arrangements. actually, we formed a tenants association. I've got her signing a document saying that she was asking for. Oh, what's your email? Because I could send you a copy of that. Because it's actually her requesting an inspection as well.
Okay.
And if you might,
My name, Mitch.
if you might want to kick two birds with one stone kind of thing, just to take a look around.
Yeah, probably will do that.
Sorry, what's it, Mitch?
Yeah, MITCH.
Yeah. At Waterloo.ca.
Brown. Yeah, that's my last name too there.
Sorry, what's your last name?
Brown, like the color.
Brown?
BROWN.
Cool. At Waterloo.ca.
At Waterloo.ca, yeah.
Okay, I'll give you the update on what I sent the other day.
Okay.
Yeah, anyway, at least with the tenancy association thing. Actually, I'll just send you the tenancy association thing for now. You probably got the rest on record, right? Like,
Yeah.
You've got a copy of the order and all that?
I don't have bylaws order, no.
Okay, do you want me to send you a copy of that as well?
Sure.
Okay.
Sure.
Yeah, I'll just send you a package with what you probably need just to get you up to speed. And you can take it from there. Mitch, thank you very much, and it's a pleasure to meet you. Is there anything else you need from me?
No, that's great, Chris. Thanks. You've helped me out.
And like I said, just give me a heads up about an hour before, and I'll make sure I can take Tiger out of here, and then everything will be ready for you.
Okay.
Okay?
Good, Chris.
Thanks a lot.
Okay.
Take care.
You're welcome. Bye.
Bye now.
You. Bye-bye.
Oh my God, oh my God, oh my God, oh my God, oh my God.
Well, that was short-lived. Yeah, no, it's pretty exciting. But again, the question remains, why is this such a bad thing? That they're supposed to check and see if it's the code. There's certainly more than enough evidence to show that it wasn't. So, Mitch Brown, pleasant guy. We had the conversation. Again, you could tell he has to get permits for all of this. That's more money he has to spend. He should have done it before we even got here. It's called due diligence. He bought the property on May 1st. He rented it May 5th. He didn't even get Becker Fire over here. He did nothing to check it. The water heater had a problem in 2018, and when they came to replace it, they red tagged it because the venting wasn't proper. So little alarm bells like that going off over the time we're here as well. Plus the flooding that happened, and a bunch of stuff like that. When you're living your life, you do what you can to knuckle down and deal with it, and then move on, right? You don't expect that it's going to be a cascade of a whole bunch of stuff because the guy's just using it as an investment vehicle and he doesn't have to put any money into it. And let me remind you, any license fee they pay, any maintenance that the cost that they incur, anything they put into for advertising and stuff is all a tax write-off against income earned. With us, he's making over $22,000, or what is it, over $28,000 over the 2 years that we paid. And again, we negotiated a tenancy legally in good faith, and these people are all interfering with it. They are interfering with the due process to be able to defend it, and they are interfering with our human rights, and they are interfering with taxpayers. They are interfering with the ability for the city to take proper revenue through proper permits. That's the way it's supposed to be done. You're not allowed to undermine it, and the legislation clearly says no person. That includes the City of Waterloo and Shayne Turner and Mayor Jaworski, Regional Rep Jaworski, or Karen Redmond, or any of the rest of you, including Dougley Ford. The ugly Ford. If you want to make Ontario beautiful again, get rid of the ugly Ford. You might want to check out that video. It's kind of a tongue-in-cheek thing. But anyway, so Mitch is coming over, right? Okay, well, then we talked to him. He called me the next day. So as we said, the call that we got, that I just played for you, was on September 3rd. It was 19 minutes, 58 seconds. Quite pleasant, right? Anyway, so here we are. Let's see what happened the next day. And this one's only 3 minutes and 30 seconds, so I wonder if you can imagine.
Hello? Hello?
Is this Chris?
Yeah. Oh, just a second. I gotta close the door. Hang on. Oh, sorry. Okay. Hello?
Hi, this is Mitch calling from the City of Waterloo.
Hey, Mitch. How you doing?
Good, how are you?
Not too bad. Did you get my emails?
Yes, I did. I just wanted to let you know that it's not going to be us that's going to be coming out. I won't be coming out from the building department.
Why is that?
A zoning and bylaw matter.
Excuse me, there are building code infractions here that we are...
Mountain.
There is no window wells.
Yeah.
There's no window wells in the driveway. They removed the window wells, and that's why it's leaking in the basement. We are requiring... Do you need me to... I put it in writing, requesting, and they are required to do building code. Who is preventing you from coming out?
So we only come out to...
Who is preventing you from coming out?
Pardon me?
Who is preventing, or what is preventing you from coming out? This is a building code inquiry. It does not meet minimum standard for bylaw. So it certainly begs to say that you need to come here and look at the building code. And we are requiring you to do it because of the improper actions of the city.
Okay.
So, do I need to make this request in writing, or am I going down to Waterloo Town Square and telling everybody what the hell's going on here? Because obviously this is obstruction of justice.
So the building department comes out on current construction, and we come out...
Well, I'm sorry, but there is a non-permitted structure here.
Okay.
You said that they are required to have a permit for the, excuse me, we are requiring a building code inspection of these properties because we are saying and claiming that it is not to code. We have, do I need to send you documented evidence of it not being to code? Because you take a look at the pictures of the window wells in the driveway, there's supposed to be a window well in there and they took it out. They did not do permits for the driveway. They did not do permits for anything, and this is obstructive.
Yeah.
Who's your supervisor?
This is a property standards issue.
I am saying, I disagree. This is building code, and I'd like to know who your supervisor is, please.
Okay. You can talk to my supervisor. I'll give you his phone number.
No, I'd like to know his information, please. Can you please give me
Yeah,
his
I'll give you
because
his
the thing is, excuse me, I'm disabled. I have a brain injury. I am asking you for your cooperation, so please state his name, spell it for me, his or her position, and then give me the number, please.
Okay.
And as a matter of fact, no, actually, you know what? What I would like you to do is I'd like you to give your response in writing.
No, I won't be doing that.
Well, I'm sorry, I'm requesting it under Accessibility Ontarians with Disabilities Act. I am requiring you, because again, I am now upset because of this. It's just another push by the city to cover up its wrongdoing. And I am requiring under Accessibility Ontarians with Disabilities Act, as well as legally, as a written response. Because this is a legal situation between the City of Waterloo, the region, the province, and tenants. And you are not following the rules. You are obstructing you are covering up for the city to obstruct the fact that this building is not to code.
Okay.
And if you don't, I'm going to call a press conference with everything.
Okay.
All of us. So I don't care what you do, but you do a written response, and that is required, and that is all we will accept. Have a nice day. So, we got the written response. And I'm going to end this vignette on this note right now because I need a break too. It's been a little rough. Okay. So I'm also going to put up points from that video with regard to some of the things he said. Such as so at 2:37 he goes, yep, yes you do, when I asked him about whether or not you needed building permits. 2:47 we'd go out there, so I asked him what would happen if it was already built. 2:47 we'd go out there and tell him to apply for a building permit. At 2:51, what if it's already been built and there a few years? We still go out there and tell them to come and apply for a permit. At 3:26, he commented, anything structural that you are altering, changing, repairing, you're going to ask for a permit for that.
period. So there should be a record of these permits for when they did the driveway, right, when they did the walls. There would be a record of these permits that they applied for if it was done properly, right? It's not hard to find. I mean, we looked at the record through MIFIPA, which was actually kept separate, and kept incomplete in many regards, and they're required to keep a complete record. Seems pretty convenient now that we got this new information too, but anyway, I'll put those notes up. There's several things. I'll try and do the transcript with it somehow. But if you pay attention, there's a lot of information there. Okay, so I asked them to please respond in writing. And let me remind you, that was September 3rd, I believe, or 4th. Yeah, September 3rd is when I contacted them. September 4th is when they said they're not coming. And what he said. Okay, so we asked for a response in writing, and this is the one that I got. And let me remind you, this is before we found out about the fire infractions next door. This is with an outstanding order. So the order is still outstanding. It's not been completed by the city. They are really afraid to come out here and do any kind of property building inspection because they already know the answer. It's not the code. They don't do inspections. And this is the answer that they gave. So taxpayers' money, with all this going on, they say the law is to protect tenants' rights and human rights, right? And the residential rental license is there to say, we've checked and they've signed this document saying that it's to building code, that it meets fire code, that there's a legitimate floor plan, and all this stuff. Okay, this is what they came up with. Here's their answer to the taxpayer, to all those legitimately operating landlords and property management companies that have no problem following the law, that pay their fair share out of the rent that they raise, that they pay their taxes, they pay their fees, they don't have to argue with rental license. This man operated for 2 years without a rental license, unlawfully collecting rent. So it's very simple. What is your definition of the term unlawful? Is he legally allowed to collect rent? It's unlawful to do so. It's unlawful to carry on a business to do so. It's unlawful to have anybody else carry it on, and that includes the municipality and the city. They are allowing him to continue a rental license without meeting the terms of the bylaw or the building code or the fire code or anything else. And somehow this is keeping public safe. I don't feel very safe. I do know one thing is that I will never sign another lease in Ontario again if they get away with this, because they're not worth the paper they're written on, even if the person's honest. You have no rights to defend yourself. They stripped us of that. It's called notwithstanding. You want proof? Here it is. Here is the letter that they wrote back. From Kevin Gerlach at waterloo.ca, GERLAC, sent September 4th, 2019 at 3:23 p.m. to crispybacon@hotmail.com. Subject, formal complaint. And this is actually the ombudsman, I believe, because I got in touch to make a complaint that said, please make a complaint online and they'll have an ombudsman deal with it. That was around the same time, and when I was doing research for following up that I ran into Mitch. So this is what it is. It says, Mr. Bacon, we have received your formal complaint regarding issues with rental licensing. Thank you for your feedback. I have discussed your complaint with relevant staff at the City of Waterloo and have been informed that the city considers this matter to be closed. Therefore, we will not be able to address the issues you have described in the form you have submitted. If you wish to continue the formal complaint process, you may complete a complaint submission form at the Waterloo Area Municipal Ombuds Office at civicombuds.ca, CIVICOMBUDSCA, or you may email them for further information at ombuds@civicombuds.ca, ombuds@civicombuds.ca. The Waterloo Area Municipal Ombuds Office is an independent dispute resolution service which investigates service complaints for certain municipalities in the region of Waterloo. Please contact me if you have any additional questions. Sincerely, Kevin Gerlach, MPS, Council, Committee Coordinators, Legislative Services, Corporate Services, City of Waterloo, 100 Regina Street South, Waterloo, Ontario, Norman 2 Jack 4A, Albert 8. Kevin.Gerlach, GERLACH, at waterloo.ca. So, they consider this matter closed. There is no, so even with the outstanding order, again, they are not enforcing it. They've decided not to enforce the order. Just decided out of the blue when it's against the law for them to even do that. Before I finish, though, one last thing. This is the part that's going to hopefully make people think. You see, I showed the other video from the other day. I showed you what is a rental license. Let me see if I can find it again. Where's the rental license part? Oh, sorry, it'd be over here. Right, rental license. Let's see, where are we? Oops. Now remember, I said that they had a rental license hanging up here, and that was the one from 2017, when we saw it in May 2017. This is the rental license that was presented at Landlord Tenant Board as evidence of a wow moment that we said. And again, you can see how it says date issued June 19th, 2019, expiry date March 11th, 2020. Issued by Shayne Turner. And it says June 19th. Now, we found out that the reason why that is actually that's a misnomer, because in researching this again, I'm going to show you what I did. Okay, so I was at the Waterloo bylaw website yesterday because I was copying the links to send you to get the copy of the bylaw, and also to the database itself, and also see how down at the bottom it says they guarantee that they're going to meet these standards. It's a guarantee. It says right on the website. Okay, so I was doing that, and all of a sudden I found another link to, I was looking up for rental license, and there's actually a database now, searchable database on the website, where you can search the rental license. So I decided, hey, just out of curiosity, let's take a look. Because as we understand it, the only license that was issued was June 19th, which he still does not have hanging here with the floor plan, which is required by the law in order to be within standard. So, one last thing. Bear with me, sorry. Here's the link to, here's the link, Waterloo. I'm going to click on it, and it takes you to the web page. Oops, sorry. Oh, that's the wrong one, sorry. Okay, anyway. Let me close that one. And, sorry, that was the wrong one. That's, that link is right here, rental license database, which I will post up. So, here it takes you to their website, and it comes to a portal, e-services, where you can search for permits. So, just out of curiosity, I'm going to do this while we're here. So let's do 100A. Well, actually, you got to go 100, then Marshall. Okay, so you go 100 Marshall, you go to the drop down, let's look, it says 100A. So now it comes up, but you got to look down here, and it says 100A here. You got to click there, and you search. And what do we got here? Oh, let's take a look at this. So, again, you notice this one is dated for June 19th, 2019. Permit number 2019004-349. And this is a photocopy. It's actually a brown legal paper looking kind of cardboard thing. And this is a picture that I was able to take on my iPhone as it laid on the desk when it was presented as evidence to the Landlord Tenant Board hearing. Now, what does this say? This says that the license 19-004349LH, which stands for licensed housing. And again, let me just show you. This one is 2019-004-349. Was issued February 11th, 2019. Rental housing license, Class A, 4-bedroom, 100 Marshall Street, Unit A, issued. Good until March 31st. So the database says that it was issued February 11th, 2019. Okay, so let's go back. And what happens when you put in 100 Marshall Street? B. Because this is applied for at the same time. Unit A, B, 98B, and 100. Oh, look at that. 100B, it says, oh, I must have done something wrong. Hang on. So, 100 Marshall. Unit B. You click B there. Search. There's no information, so does that mean the 100B is not licensed? It's funny it was there. Okay, so now 90, let's check out 98 Marshall. Because 98 is where, that's where Carrie lives. That's our other building for our association. And see what they say there. So does that mean they're not licensed? I don't know, something might be wrong with this. Let's do another submit. Did I do something wrong? Let's see. 98 Marshall. Unit B. Ah, here we are. Okay. 98B. There you go. So again, we have permit number 19004-347, which is different from this. This one's 349 for 100A. 347 LH is for 98B. It says it was issued February 11th, 2019. Class A, 4-bedroom, 98 Marshall Street. Unit B, issued. Good till March 31st, 2020. What this means, people... What this means, people, is very simply that they gave the license to them sight unseen. There wasn't even the fire inspection done here yet, February 11th. We saw the results of the fire inspection. As a matter of fact, I've got the precursor to that, which is the actual fire inspection. I put up the one that Meta did that day, but I did not put up the fire inspection that happened just before Meta that day, which was the first fake inspection, May 30th. So I will be posting that fire inspection because you need to take a look at it and see that these people were totally surprised by what was in here because they had never completed, in our opinion, they had never completed a physical fire inspection of this property either until that date, which it failed. We posted the video of the noticeable failure next door at 98B. If this in fact was, and that makes everything into perspective now, because that means that the landlord had his deal in place and knew it was going to happen before it started in May. The city was caught off guard because we made our complaint, and I backed it up with photographs and with the legislation, the actual parts of the legislation that were affected, which means that that February 11th one is now in jeopardy. They had to come out here, and if you look at the videos, they are trying to avoid and read the situation to see if we can trick brain injured guy in them into just, accepting a little Band-Aid thing. And they knew right away they couldn't. That's because, and everybody's wondering, well, I used to be the president of a co-op association here in Kitchener for over 2 years, who the whole purpose is bylaws, making sure you're to code, dealing with city, and certainly when they're coming after you for bylaws, when you're the one in infraction, usually, unless of course you're Theo Papadopoulos, commissions worldwide, they get a free pass because they paid for the privilege, obviously. There is something seriously wrong going on here, but that means that the city, that changes the whole tone of what the city did as far as this whole action. This now is definitely a criminal matter. This is obstruction of justice. They are obstructing their own municipal act, and I'm calling on Karen Redmond in the region to fulfill that municipal order as required under the Municipal Act. I am also requiring that the parties that have done this need to file that order directly with the land registry office immediately and pay for the cost themselves. We are asking that all actions with regard to any kind of eviction from here be ceased immediately because, hey, City of Waterloo, province, region, look me in the eye when I say I dare you to fucking, excuse my French, I dare you to evict us based on this. And besides, they win this. The entertainment portion is going to happen because I will not be relenting my home this time. We leased this property. We paid for the rights. He gave up the rights when he accepted that rent, unlawful or not. Fact remains. He has 4 applications that are false before the board, or before the everybody. He filed a knowingly false application for eviction with the Landlord Tenant Board. Misrepresented and fraud. From 2000 to 2019, February 11th, 2019, or June 19th, 2019, he was not licensed. Therefore, it was unlawful to collect rent, cause rent to be collected, etc. It's in the legislation. It's very clear. He's the one who had total control of this and the city. We're caught in the middle, and our claim is this. We've already paid 2 years of unlawful rent in advance. He was supposed to honor our terms of our lease. He still hasn't because the lease didn't start yet because it's not a lawful rental yet. As soon as it starts a lawful rental, we should be able to start our 2-year lease as negotiated. The only reason why this is happening is because the city was caught obstructing justice and in their business plan of exploiting both sides of the law while not upholding any of it. This is a human rights issue. December 19th, 2018, which is actually 7 days after that story was published by Jeff Outhit in the Waterloo Record. Notice to 100B of the violation and requiring compliance. Now, again, in reading this, they didn't send that to 100B. They sent it directly to the person who's at fault, which is the corporation, Worldwide Commissions. When Worldwide Commissions gets one letter of that, it applies to every property in Waterloo. This is a real estate agent again. He knows what he's supposed to be doing, and he's supposed to anyway. There are serious questions here about this business plan and how it's implemented, especially when it comes to human rights. And especially when it comes to our ability to defend ourselves. And they just throw us into the quagmire of, oh, I get to go and start this all over again with the ombudsman? City of Waterloo needs to come forward and tell who is their representative for disability. Who is the disability coordinator for the city? Who's the disability coordinator for the region? There is none because they don't need to, because they don't follow the law at all. They don't have to. There's no checks and balances. You get to go back to them and ask them if they're doing it. January 2019 is when we got the notice of the inspections to 98A, 98B, 100A, and 100B, and that was sent in the letter from the landlord. So the landlord is who informed us that all 4 properties were not legal. Still aren't. The applications for which were submitted between January 19th and February 11th, 19th, with legal declarations. So sight unseen, if this is to be believed, They issued those licenses sight unseen February 11th. The reason why they had to change this one to January 19th June 19th is because they had to antedate it for after the order, is what we believe. But either way, neither of them are valid because of the order, and especially because of the order. Read the legislation. Not even Shayne Turner is allowed to do this. This is harm, damage, harassment, obstruction, assault, human rights abuse. And again, where's security of person? Everything attached to security of person: education, employment, financial, medical, legal, pensions. So security, income security, pension, stuff like that, insurance, banking, all of these things, if they're entrenched in the and enshrined in the Charter of Rights and Freedoms, which is our Constitution, then why is every one of these things that are tied directly to security of person run by quasi-judicial kangaroo court system with no obligation to the law or anything other than their whim? That is exactly what landlord-tenant just did. We gave them fully documented evidence of more than enough evidence to show that this man represents. His lawyer misrepresented. The legislation clearly says that in a situation like this, they are not allowed to evict. But their whole purpose is to direct us out the door, because we're the ones who brought this to people's attention. How dare us? How dare we question why Denise is hurting herself every time she goes up and down those stairs in the back? That the dog gets harmed, his paws, because again, it's not the proper angle, it's not done to code. And he already fixed that once while we were here, because it was sagging when you go down the middle. Didn't even support anybody's weight. This is a simple thing. It's black and white in the books. Minimum standard is not something you work up to, it's what you get. And you know, it should have been as simple as Mitch. Mitch should have came out. It's one person for building, one person for standards. They come out, they're impartial, they have a checklist, they go through the checklist. What's not right gets marked, and you indicate this isn't right, this must be corrected. They give them time to correct it, they work with them. Other people are able to do this, no problem, because they're willing and able, and it's not about just bleeding the system. We contribute to this system and we're treated like we're nobody. We're not even allowed to have a safe place to live, let alone a safe place to work. And any complaint, we become victimized and then criminalized. Talk about victimized. Again, we've been distracted because our friend John Thomas Lichten passed away from a heart attack brought on by the stress. And don't let the picture fool you. This man had a heart of gold. This is him when he was down at Ray of Hope. Oh no, it actually looks like Tim Hortons. That's more Tim Hortons when he was hanging out at Tim's. He used to hang out and help people. And he was a well-respected member of the community. Very giving man. He had his dogs, and I was the one who helped him get this place, as well as the one next door, for the people next door. So I helped populate these units on behalf of this thief. And I'm not talking about John. John isn't the thief. Theo Papadopoulos and the city are. But we were promised a fenced-in backyard the whole time. Tom had 2 dogs, which he'd have to let out, and we kept on getting promised this fence and not going through. But in the meantime, because Tom had to tie his dogs up in the front, because Carrie, he's disabled. Carrie's not that well for that. Anyway, regardless, they have the right to do that. But every time Theo would come to pick up rent, and other times he would show up and he would be complaining about the dogs. And, that they're in the front all the time. And to which we'd always say, well, you're supposed to do the fence. Give him his fenced-in backyard. He did a dog run in the back and all that. He did what he was required to, but again, it's all about this fence. And every time he'd come and he'd give him a hard time, and Tom would get upset. And, the interactions were also caught on security camera, including video and audio. Tom would come over and talk to me about it and go ask what the hell's going on with this guy, how he thinks he can come over and harass him all the time. But again, look at what happens when you do have the wherewithal behind you and you make a complaint. The whole system is geared to suppress. The other thing you don't know about John Thomas Lichty is in the way that he died is he was at CCIB, or what is it? The CCICVU, which is Cardiac Care Unit ICU, St. Mary's General Hospital. And that was, he died July 18th. And he went in for open heart surgery because he was having trouble with his heart. And because of the stress in that, for whatever reason, I don't know all the details, but all I know is that when he was going in, we had discussions, and it was his intent that he was not going to, if he wasn't going to make it out of there, he was, anyway. The point is this, when he went into the hospital, he deliberately on the form for substitute decision maker left it blank because his best friend and co-tenant Carrie, they were almost like brother and sister, not husband and wife because they weren't together that way, but they were definitely like brother and sister and really, really close together. They loved each other, and even if they, I don't know, I can't define their relationship. All I know is what it was. But anyway, the point is that he did not want her to be making any decisions. If he wasn't going to make it off the table, he wanted the doctor to be the one to make the decision, which is why he left the form blank. The hospital, in their wisdom, somebody made a mistake and assumed because of the way that they were caring to one another that she was common law, so then thrust her into that position of making substitute decisions, even to the point where they made her sign a form. We had a meeting about it with the hospital, and they pointed out again, they were sitting there saying, well, you're common law, right? You're common law, because again, they pointed out, and my understanding of it, they were acting as if she was substitute decision maker. So that's why I was asking questions regarding substitute decision maker. But because of that, at the meeting, they pointed out to us that there was no signature for substitute decision maker. And then it hit me, why? Because Tom did not want Carrie making that decision. It was to be the doctor. But yet, here's the problem. The hospital thought and they carried on after that. They said, oh, you're common law? Okay, good. That covers us then. Carry on. And they kept on getting her to sign documents. Matter of fact, they had her sign a document after that with regard to an operation. They actually went through the process of having her pull the plug. But they didn't take her decisions after that. We asked for documentation in order to cover the legal aspect, because Tom did, in his last wishes, leave his estate affairs to Carrie to be able to carry out for him. And anyway, it doesn't matter, but we were trying to save his life. And every time we got him to communicate, they would shut him up again. But there was serious problems and implications with his care, and it had nothing to do with any of the people that were working on ICU, because all those people were fighting for his life just like they're supposed to. They are as much victims or more victims of this than we are. And Tom was. Because I bet you this isn't the first time they've been made to go through this. We were fighting, everybody thought that's what Tom wanted. And he had a bad situation. He was shocked again and again and again for over 14 days. He was, basically what it amounts to is this. His medical directive was not to be saved. His medical directive was to let him go and be the doctor's deciding factor. Because they made this medical error, they thrust Carrie into a situation and the rest of us into a situation, especially the staff, who were made to keep him alive for, I think it was 14 or 18 days. Every procedure that was done to him from that point, when the doctor should have called it, was done against his medical directive. This was known to the administration. And when the administration found out about it, and we found out about it and started pressing it, they pulled a wet lawfer. They shut everything down. They even tried to have mess with the family as far as the body. We had a meeting. I've got it all recorded. We immediately got in touch with the coroner's office and said, sorry, no, this needs to be coroner. And of course, that politics happened. And this is all while we're trying to deal with this stuff too. So again, this is the regional coroner, the region of Municipality of Waterloo. And go to the coroner's website. Coroner's website says clearly that the coroner's office is supposed to be impartial. They are there not to find criminal liability or anything like that. They are only there to go through the process step by step to see if there's any mistakes that were made, anything that could be changed to make sure nobody goes through it again. Has nothing to do with criminal liability at all. It's only from a medical perspective. And especially for the CC, cardiac care ICU unit, the people that are fighting for patients on that floor, how dare the administration do what they did? Because this is what should have happened at that meeting. What we found out is this. When they found out the medical error that they made, they just kept her in the gray area. When they needed her to make a decision so that it looked good, they go, what do you think? And give her the decision-making power, and she'd make the decision, and they do it. When it wasn't convenient for them, they ignored her. What happened is this. The minute that the lawyer for the hospital or whoever, the administration, found out there was a medical error like that, they got in touch with the advocate, the lawyer advocate, like they're required to, which the lawyer advocate's job is to advocate for the patient. There's only one job that person has. In a medical error situation, that person is to do nothing but advocate for that patient. So here we have a hospital and the lawyer advocate talking with each other, and they came up with have a meeting and have her admit she's legal, that she's common law. Somebody came up with that, but that would not survive the legal test. Even that would not survive the legal test. They screwed up. And they were so busy because we were asking for documentation in order for her to become the executrix of the estate, because a process has to be done. They like I said, it ended up being bad. We got Tom died. There's serious questions about his death, especially with the act that they put on for Carrie to go through to make it look like we believe he died much sooner. Anyway, we asked for an autopsy. I have the copies of the phone calls with the coroner. First, it was a coroner from the hospital that tried to say, oh, well, we knew what he died from, just let it go, right? And I'm going, no, because I knew the legal implication of what that meant. That advocate did not advocate for John Thomas Lichty. What should have happened is the minute that the mistake was made, that lawyer should have been on site going, this needs to stop. Because he's there to represent John Thomas Lichty's wishes, which was, if it was not to be, the doctor would be the one to call it. And that should have happened weeks ago. But they didn't. Instead, they had a meeting, and they tried to smooth it over, calling it common law. They made it worse. The staff were traumatized as much as we were. Even more so. And to think where they would be for the trust issue, because again, if they knew the extent that these people went to cover their tracks and pull a wet lawfer, because wet lawfer was just about get her out the door, not on our insurance, not on our record, shh, next. Just like this one. Just like here. Wrongdoing by the Crown, by anybody representing the Crown, or in contract with the Crown, it's minimize their criminality and get them out the door. It's called privilege. Anyway, I'm sorry, I don't mean to be yelling at the camera, and I didn't mean for this to be going on for as long as it has. 1 hour, 24 minutes. People, you need to wake up. I'm putting on, the one you need to listen to now is actually, I'm going to tack it on to the end of this video. It's about 32 minutes. It's the actual first contact with Shamir Mehta. From the telephone contact. Actually, I don't think it's the first one, but it's actually the first one where, because we were asking for a meeting. And they're saying, well, come on into the conference room, we'll have one here. But based on my experience with them before, whenever they do that, that's because they're trying to get me into a public place to set off my PTSD so that they can victimize me, criminalize me, and have me arrested. Because, hey, don't listen to that crazy person, right? We knew better. So I sat there, and a brain-injured guy that I am, again, people keep thinking that means stupidity. I may be hindered somewhat, but I am not stupid. So anyway, they think it's stupidity. Well, here's the stupidity for you. So they're going ahead, putting together what they called a meeting, which was actually just going to be Shamir and myself. You can hear the details of it in the phone call. And I had already made up my mind that, well, I was going to ask them how much time they set aside for this meeting. Because I knew it was going to be at least an hour, possibly 2, if they knew anything about my disability. And again, they did nothing to accommodate disability, and the request was originally through AOTA back in May with Kristen, which you will also hear me comment in this conversation about. You're going to follow that up, right? Anyway, 32 minutes, but it's well worth the wait. It's well worth the listen, because it really puts it into perspective, especially now that you know that they actually gave them these licenses February 11th, 2019, sight unseen. And when you put it in, where's the guarantee that this was to code? It still isn't today, 86 days later, or whatever the hell it is. 83 days later as of today. Anyway, I'm going to put that on at the end. I think all I do is just tack it on as audio. So please listen to it. In the meantime, I am going public. I am going out, and I am going to be publicly declaring that Mayor Jaworski, Representative Jaworski, is a liar. That the City of Waterloo is engaged in criminal practices and human rights abuses using their rental license bylaw as the vehicle. And it's time we end this charade once and for all. And anybody running for federal government, please tell me, where is security a person? Why should I ever believe any of you ever again? I've been through your system. We are declaring that we are looking for somebody to help us put together a written complaint to the UN Special Rapporteur for Human Rights, and also the Committee on the Rights of Persons with Disabilities. Because Trudeau, you lied. Government of Canada, you lied. They get submitted. They made a submission to the Committee on Rights of Persons with Disabilities regarding the disability system in Canada, and they forgot one big part. Every single agency that is supposedly representing disability is not allowed to act independently. They are only allowed to send you back to the legal system that is there to suppress and to send you back into this system. Like I said, this is full circle now. The last time I went down, we hired a lawyer, Michael Ferguson, retained to help us get accessibility and to deal with this issue up at 49B Marshall. Electrical Safety Authority, same thing, recorded, interfering with your ability when they're supposed to be impartial, because the landlord was an one of the top electrical guys, and he did all of his own electrical in the house. What do they call him, a master, electrical master? You know, like I said, this is all very telling. They stop. It is about suppression of rights. And Queen Elizabeth, you're full of shit. Time for you to go, lady. You're the biggest welfare case there ever was. Anyway, I gotta go because I'm tired, and this is unfathomable. This has been nothing but an assault. Psychological warfare deliberately sent on us. And Brian Larkin, you can hand in your resignation too, because I'm about to publish every contact with Waterloo Regional Police, and you are the chief. You're responsible for training, right? You are harming officers. You are putting the public at risk. You need to go. You make Sid Brown look like a Kid Scout. He's rolling over in his grave right now because you just took his crown. Hope all is well with you and yours. Be well, okay? I'm trying. Have a nice day. Please speak out. Please help us stop this travesty of justice.